Lost another sheep last night. That's another story for me.
A sheep? You got predators or cold weather or what is it? Oh,
We lost 4 of them in the last week.
yikes. You have a Great Pyrenees? You need Great Pyrenees.
Oh no, they're not being attacked. They're free dogs. They are just getting sick. Saddest thing in the world. Go check with him real quick.
Yeah, yeah.
Yes, do I not look like I'm doing well? I mean, I'm tired.
I can only imagine. All right, anything we need to address before we bring the jury back in?
No, Your Honor.
Nothing from the defense, Judge.
Let's have Mr. Ross come on up. Mr. Ross, just remember that you're still under oath, okay?
Yes, ma'am.
All right, let's go ahead and bring our folks in, please. All right, looks like we have all our jurors back here. Good morning, everybody. All right, at this time, the witness is still you.
Thank you, Judge. Good morning, Mr. Ross.
Good morning.
Welcome back. Yesterday, you had some time to sit on the witness stand and provide testimony. Do you remember that?
Yes.
And we ended off talking about when you got to Delaware, and you said that your sister had found out what happened. What did you mean by that?
I was indicating that she had found out that me and my mom had gotten into that verbal altercation. I got removed from her residence and couldn't stay with her anymore.
Okay. Now, yesterday, we were talking about some of the conversations and interactions you had. One thing you had mentioned is that you had had a falling out with Thomas Blackwell. You remember that?
I do.
In addition to that, you also had a falling out with Mr. Sykes.
I did, yes.
And what was the issue about? What occurred?
Sykes, he's gross, honestly, in my opinion. The same day that I had fell out with Christian Sykes was the same day I also fell out with his cousin, and we were at his cousin's house. We were smoking marijuana, and I had seen Sykes giving his cousin oral pleasure, and it grossed me out. And so I called my mom, asked her to come get me. I left. I went to the top of the street. She came and got me, and I didn't contact either him or Thomas Blackwell since that day.
You mentioned that on the Sunday after this incident on Buckhorn, that Mr. Sykes had called you to apologize. What was that in reference to?
That was in reference to me seeing him give his own cousin head. I reckon he was embarrassed and that he wanted to know. Basically, he didn't necessarily tell me that he wanted to know this, but I think he feared that I would like expose
Objection.
him to somebody.
Hold on. Sustain. Speculation.
Just let us know what you said and what was in your mind.
What was in my mind was that he just wasn't someone that I would want to be around necessarily. That's not normal to do something like that. You know, it's your cousin. It's just, it was crazy to me. I couldn't really fathom it, but
Now, on that day, the 18th, that Sunday, how many times did Mr. Sykes call you before you actually answered?
he actually called quite a few times. He also sent messages. And as long as I'm present on the app itself, I can't mute his notifications. As long as I'm on the app, it's gonna show up anyway, unless I go and disable it, which I never really got to that, but it just kept showing up on my screen. So I slide onto our chat and I see he's just sending a bunch of messages about, you know, please pick up, we have to talk. And I pick up the phone. And while I was on the chat, actually, which was when he called, once he called me on the chat while I'm viewing the chat, my camera automatically turns on. And so he can see me and I can see him. And so whether or not I answer the phone or decline the call, he's still seen me while the phone was ringing, as long as I'm present on the chat. And so he's seen me, I seen him, so I'm like, all right, I might as well just pick up the phone. I picked up the phone and he's just going off about how, you know, he is embarrassed. I shouldn't have seen something like that, and he wanted to know if I wanted to smoke and kind of talk about it more. And I was just, I didn't want to do it. Figured he was trying to get into, in my opinion, it seemed based on his wording and how he conducted himself in that situation, that he wanted to.
Objection.
Just stick to what you know and what you heard and saw. So after he made this apology, what did he say next?
He wanted to know if I wanted to smoke with him and talk about it more. And I told him I didn't want to. And that's when he kind of got quiet for a second. And he had seen my face on the phone. I'm just looking, I'm like, is that all you had to call me for? And he was like, well, are you good? Like, what's going on with you? And the situation was still fresh, even though it had happened 2 days prior. It was still fresh to me, you know, life or death situation. I was all over the place, and I told him, you know, I had said that I had almost died last night, but I know what I had said last night. That was just letting you know that I really was all over the place. I had said last night, even though the day before I was with Antoine Bryant, which also actually, this phone call occurred on Sunday, the 18th, I believe, and he actually said that we met up on Saturday, the 17th, at around 4 o'clock, from what I remember from his testimony, when he had gotten off of work, 4 o'clock, that he came and met me at my mother's apartment in the parking lot. But that's one thing that he said that didn't really add up. He said that we met up to
Objection,
smoke.
Your Honor.
I'll keep him in line. Let's just talk about the call. So he asked you how you were, and how did you respond?
I told him that I had almost died last night. Excuse my digression. I apologize. I had almost died that last night, even though it wasn't the night before. I was just mixed up with my timing. I told him I had to shoot him. I never said them. Two people ended up hurt, and nowhere did I reference me harming two individuals. Nowhere did I mention me harming two individuals inside of my mother's vehicle. That's evident. State's evidence does not
Stick
imply
to what
that
you
at
said.
all.
Objection.
Stick to what you said.
Okay.
Uh,
Mr. Ross, you may only testify as to what you've seen, what you said, what you heard, all right? Not speculate about what people thought or were thinking, all right?
And so, after you made that statement, what happened?
I'm sorry.
After you told Mr. Sykes this?
Well, after we had gotten off of the phone, that was pretty much it until I was on the way to Raleigh. He had sent me a screen capture of the images of Devin Clark and Lyric Woods. That was when I had found out who she was. And he said, "What the F?" Asked me if I was all right, and I said, "Yeah."
And that was the last time you spoke with him?
Yes, to my knowledge, yes.
And on this time when you're communicating with him, either by the video chat or by text, that's all through Snapchat, is that correct?
That's correct.
And your understanding of Snapchat when you use it, once you send a message,
Objection.
this is based on his use of the app. Okay. When you use the app and you send a message, what happens?
When I send a message, when anyone really sends a message on the app, you have the option to save it right then and there, unless the chat has been on preset settings. You have the option to save it right there or not save it, and the messages that were sent that aren't saved will be automatically terminated upon swiping out of the chat itself. So everything just kind of erases.
And so you as the user, have the ability to save these messages?
Yes. Both from both parties. Either I could save I can save my messages and his messages, and it's vice versa.
Okay.
And if you don't save it, they terminate. If you do save it, they stay there for as long as until someone deletes them or unsaves them, and yeah.
And that early morning or night of the 17th, you were invited out by Devin. Is that fair to say?
Objection leading.
Who invited you out on the 17th?
I was invited by Devin Clark.
Who brought the firearm that night?
Devin Clark.
When you got out the car at Buckhorn Road, who shot Lyric Woods?
Devin Clark shot Lyric Woods.
And after he did that, what did he do to you?
He came over to me with the gun, pointed it at me, and said that I knew what time it was, which would mean he's about to kill me.
Objection.
He was about to kill me.
Hold on.
I'm going to overrule it. It's his perception of you that. You may continue, Mr. Ross.
He was going to kill me, and I had no other choice. It was a life or death situation. If I would have sat there, I would have been dead. And whether or not, I'm sorry, I was about to
It's fine.
speculate again, I guess.
That's fine. Just
You can talk about your perception of what you perceive. That's all right. You can't speculate as to what other people are thinking, okay?
I would have died.
thank you.
I would have died. if I had sat there and let him do what he was going to do, I wouldn't be here speaking to you guys right now.
One moment, Judge.
Yes.
Am I allowed to keep speaking?
No further questions, Judge.
All right, Ms. Ross, cross-examination.
Thank you, Your Honor, and good morning, Mr. Ross.
Good morning.
So you and Mr. Blackwell had a falling out about a year before this incident, is that right?
That's not correct.
How long before?
Actually, we had just went on a family trip prior to that falling out. I would say it was the same year of 2022, not long before this incident occurred.
Okay. And turning to this incident, you picked Devin and Lyric up and drove them to the area where their bodies were ultimately found, is that right?
That sounds about proper, yes.
And you got out of the car, is that right?
I did get out of the car.
And you were using Devin's vape pen at the time, right?
Yes, that's correct.
They remained inside the car at that time.
Well, not necessarily. When I had gotten out of the car, Devin also gotten out of the car, and that was to transfer to the back seat where Lyric was.
Yesterday, you testified that you didn't see that happen, but you thought you heard a car door open, is that right?
Yeah, we pretty much got out at the same time. After he handed me the pen, we both got out, and yeah.
Did you see it or not?
I didn't watch him get out of the car because I was getting out of the car myself.
And so you waited some distance away from the vehicle while they presumably had sex, is that right?
That's correct.
And you were on your phone at that time?
Don't really recall. I'm pretty sure, I had my phone. I had just been scrolling on my phone using the vape pen.
Then you saw Lyric get out of the driver's side rear door and Devin get out immediately behind her?
I'm sorry, you said driver's side rear door. That's the back left. Yes, that sounds about proper, yes.
And you believed that they were arguing, is that right?
Well, before they had gotten out of the car, there were muffled sounds. It sounded like a not normal voice level, but once the door opened, I could hear better. They were arguing.
After Devin shot Lyric, he approached you and asked you if you were ready to go, is that right?
He asked me if I was ready to go and if I would be quiet about him killing Lyric. And I said, heck nah, like, this is your crap, deal with it. I'm gonna leave. You can deal with this on your own.
And so then he pointed the gun at you
Yes,
and you lunged for it and also attempted to headbutt him at the same time?
yes,
And then you got control of the gun and started shooting Devin, is that right?
yes,
And Devin started moving away from you toward where Lyric fell, is that right?
well, the shots that I fired were pretty rapid. It wasn't just like a boom, boom, like that. I just fired the gun. He turned, and he fell a short distance away. I didn't shoot him anymore.
So could you see whether he was facing you or facing away from you when you were shooting?
Yeah. It seems like when I had first gotten control of the gun, after he had punched me right here, as soon as the barrel looked like it was turned towards him, I started firing the shots. I couldn't really see if I was hitting any of them or not. But yeah, it was pretty dark outside, and I don't really have the best vision, so.
Okay, and then he fell face down on the ground, is that right?
Yes, that's correct.
And you went to go get back in the car, but realized that you might run over his legs if you pulled forward, is that right?
That's correct.
And so you took off your camo jacket and took off your quarter zip. What color was that again? I didn't get it yesterday.
It was black.
Okay.
It's a black Under Armour quarter zip.
So you took that off and used it to move Devin's body, is that right?
I had originally tried to pull him while he was still face down, but it was kind of hard. So that's when I had removed my quarter zip and threw it on top of him and pushed him over so that he would be face up.
And then you dragged him so he would be out of the road.
Yes, that's correct.
Is he still alive when you did that?
No, he wasn't.
Was he breathing?
Not that I know of, no. I know I seen his eyes were kind of still open when I had flipped him over. His eyes were kind of still open, and I noticed his mouth was also slightly ajar, and he looked dead.
Did you check for a pulse?
I didn't.
Was Lyric still alive when you were doing this?
No,
Did you check?
I didn't. But given the fact that after he had shot her, she was still alive for a minute because she was kind of rolling around on the ground, and after that altercation had happened with me and Devin, she wasn't moving or making any sound anymore.
So when you left to go get gas, Devin was laying face up near where Lyric had fallen, is that right?
That's correct.
And was Lyric face up or face down?
Lyric, I believe, from what I remember, she was face up.
So you left, you realized that you still needed to get gas. So you went to the Petro, right?
I did.
And on the way to the Petro is when you realized Devin's bag and his other belongings were still in the car, is that right?
That sounds about proper.
And so you took the bag, the gun, his phone, the vape, any other items he had left behind, and you threw them out of the car into the woods on Buckhorn?
Yeah, I had the vape in my pants pocket, but his phone and the gun were on the seat and his bag was on the floor. I just got out of the car and chucked it into the woods.
Okay. Then you're at the Petro, you get gas, we saw that on the video. And then you went back to the scene because you realized you forgot the quarter zip, is that right?
That's correct.
And you went back there, you picked up the quarter zip, and then you left and went home?
No, when I had grabbed the quarter zip, it was still near the bodies. And when I had seen them again, I kind of got sick, and above them, somewhere above them, I had just started, I thought I was gonna throw up. I was kind of just gagging and spitting, that kind of thing, but it was pretty bad.
But you got your quarter zip,
I did.
and then you headed home.
I did.
Now, when you got home later in those early morning hours, did you send any messages back to the group chat that Devin had originally reached out to you on?
I don't really recall.
Okay. Do you have the Instagram handle, or excuse me, Snapchat handle DRXIPPY7?
Yes, that was my older handle. That was my older username itself. Later on, I had changed it to POURTRIS. Um, I'm not really sure why it still showed up as my older handle, but
Okay.
yes, that was me, yes.
So at 3:52 a.m., the message from that handle, DRXIPPY7, to the group chat says, "My B, I was slump." Did you send that message?
Yes, now that you say that, it sounds about proper, yes.
And what does slump mean?
Asleep.
And then just after you sent that message, you sent a message that said, "Nah, I don't got my wheel yet, and my mom never trying to let me wheel her SHII." Did you send that message?
I don't really recall, but evidently, evidently.
And then just following that, you at basketball_1296. Is that right?
I don't recall, but if that's what's showing up, then evidently.
And so you sent these messages knowing that Devin was already dead, right?
I did.
And then on September 18th September 17th, late in the evening around 10:19 p.m., the guys in the group chat were talking about the fact that nobody can reach Devin. Is that right?
It sounds proper.
And you sent a message to the group chat that said, "Bro, I'm not even in town, bro. This shit crazy. What the fuck?" Right?
I don't really recall, but if that's what's showing up as my message, then evidently.
And just after that, you sent another message that said, "No way this N-word Devin missing." Is that right?
Don't recall, but if that's what's showing up, then evidently.
And you guys talked about this for quite some time both in the evening of the 17th and then during the day on the 18th. Is that right?
I don't really recall. I do remember them messages in the group chat about Devin, and I was paranoid about everything, so I was just trying to play as if I was never even there.
And on the 18th at about, if I'm doing the math correctly, 9:30 a.m., you sent a message to the group that says, "I'm talking to Mo. They say Dev is at home, question mark, question mark." Is that right?
I don't recall.
Who's Mo?
Mo, that would be my mom's ex-partner, Antoine Bryant.
Okay. And you say you told Mo that he was missing?
I don't recall, but if that's what's showing up, then
And you sent a message at 9:38 a.m. that said, "I'm saying because if he was at home, why he not letting us know he's straight?" Is that right?
I don't really recall, but messages.
And at 10:02 a.m. on the 18th, you sent a message to the group chat that said, "This shit making me sick to my stomach." Is that right?
I don't really recall.
And then on the afternoon of the 18th, when the news starts circulating that Devin is dead, at approximately 6 p.m. on the 18th, you sent a message to the group chat that said, "Nah, I don't believe that shit." Is that right?
I don't recall.
And just after that, you sent a message that said, "Mo just told me,"
I don't recall.
and that he just got a call.
I don't recall.
Your Honor, if the line of questioning about the specifics of this, if that's the states, I'm going to object because he's mentioned on at least 6 or 7 occasions he doesn't remember these exact messages. So.
Overruled, he can be asked about them and he can indicate as to whether each message, whether he remembers sending it or not.
And at 6:08 p.m., you said, "I'm stuck, bro."
I don't recall.
And at 6 on the 19th, Monday the 19th, at 6:22 a.m., you said, "Bro, I'm sick. I can't even slide, bro." Is that right?
I don't recall.
And then you sent a follow-up message that said, "I'm out of state." Is that right?
I don't recall.
And that would be after you arrived in Delaware, correct?
I don't recall.
You got to Delaware on Monday morning, is that correct?
Sounds proper, yes. I left for Raleigh in the evening of Sunday, and I arrived in Baltimore where my sister was waiting for me that early hours of Monday, and we drove the rest of the way to Delaware.
Okay. If I could have just one moment, Your Honor.
Yes, Ms. Wolf.
Thank you. Your Honor, that's all the cross-examination I have. Thank you.
Yes, please. Mr. Ross, when you were talking to the state, you were talking a little bit more about your interaction at Buckhorn Road. Can you explain to me what you heard or what you remember you heard when Lyric and Devin got out the car?
She was yelling at Devin, saying that I can't say word for word, but that I remember she saying she wasn't a whore, and she wasn't gonna let him pimp her around anymore, and that she was gonna get police involved.
And how did Devin respond?
Ultimately he retrieved the gun out of the car and then shot her with it.
Okay. And back on September the 18th, 2022, about how big were you? How much did you weigh?
Um, uh, Not much. I wasn't as taller as I am now. I'm pretty sure I didn't weigh as much as I am now either.
So how much then though? How tall were you and how much?
I'd say around 5'10", weighed probably 140.
And around that time, how big was Devin? Was Devin bigger? Like how tall was Devin? What was his description?
If I had to guess, I would say he was about maybe 6'2", 6'1", something like that. Can't really, he wasn't really of the muscular type, but he wasn't too slender either. Had like an athlete type of build.
So around that time, would you say he was, how would his size compare to yours?
He was bigger than me, yes.
And so at this moment, Devin runs around the front of the car to which door did he go to?
The passenger side door, front seat.
All right, and so did he have to pass you to get there?
He did, yes.
And then when he came back, what was his initial response when he first came back from going around the car?
He pointed the gun at Lyric.
And what did she do?
She threw her hands up and started backing up, and she's saying something to him, but I'm yelling at Devin too, seeing what he's doing. You know, I didn't even know he had a gun, and yeah, he kind of backs her up. She wants to turn around and go towards Buckhorn. It looked
Objection.
like.
Mr. Ross, please only describe what you're seeing, don't speculate on what people think.
I apologize. By the way she was moving, would indicate that she was trying to elude Devin
Objection.
Clark.
Describe what you saw.
She was moving away from Devin Clark. She had her hands up, and he walked her down towards the rear of the vehicle where the trunk is, and that's where he shot her at.
Okay. And then you didn't immediately get in the car and drive away. What did you do?
Well, while he's backing her down, I step in. I wanted to go up and try and defuse the situation if I could. He ended up shooting her. Of course, I didn't think it would go like that. And so I was going to try and interject myself and try and put an end to the situation. Do my part, because I'm not going to just sit there and let this happen, you know. I didn't even get to go and try and do anything to defuse the situation before she was shot. I'm sorry, did I veer off of the original question?
You answered the question.
I answered the question, all right.
Now, you were asked a question on cross about what did Devin do once you took the gun from him? How quickly did all that happen between the time Devin put the gun in your face and the time that you started wrestling with him?
I would say in less than a minute. It was a pretty quick situation. It just happened quickly. Very quick.
And when you said that when you were kind of interacting with Devin, you said that Lyric might have still been alive, or has she passed away at that point?
By the time the gun was in my face, I wasn't looking at her anymore. I was focused on what was happening now. You know, there's a gun in my face, you know. But I do know that after Devin was shot and I was able to flip him over, she wasn't crying or moving anymore.
And when you were about to leave, did you get in the car and leave immediately, or what was the time frame between the time that you had this interaction with Devin and the time that you tried to move his body? How much time passed?
I don't really recall. It wasn't a absurd amount of time. It wasn't just in a few seconds either. I can't really place a timestamp on it.
And then after you left the scene, um, what did you do with the things that belonged to Devin?
I'm sorry.
After you left the scene, after you left the service road on Buckhorn, what did you do with the things that belonged to Devin?
I got out of the car and chucked them
And why did you chuck them?
because, I mean, I had no business with them. Just a gun, somebody was just shot with, and then I had to shoot somebody with it. And then also the fact it didn't belong to me, so I had no business having it. His phone, I had no business having it. His bag, I had no business having it. I threw him.
And on this day, September 17, 2022, how old were you?
I was 17 years old.
There was a mention, there were several questions, a line of questions that you were asked in reference to specific messages you sent on Snapchat the morning of the 17th going into the 18th. Do you remember the details of those messages?
I don't.
But you do know that you were on Snapchat at some point on the 17th and the 18th.
I would say yes. Yes.
Okay. And in addition to sending messages on a group chat, you also talk with Mr. Sykes on Snapchat. Is that right?
I did. That was on Sunday.
And these messages, I think you had mentioned, what happens to these messages when you send them to people?
They delete.
Okay. What was your state of mind after this event on Buckhorn? What were you thinking? What was in your head?
I was very paranoid, distraught, just scared. I couldn't think about anything else, but I just kept thinking about what had just happened just over and over. I didn't really get any rest that night. Yeah, I was all over the place. I was pretty messed up.
Now, this night of the 17th, or early morning of the 17th, was this the first time you saw Devin with a gun?
No. I'd say every time I seen Devin, he had a gun. The first time I met Devin, there were a lot of guns. We were actually at Antoine's sister's house. His family had came over, and they were doing like target practice in their backyard.
Nothing further, Judge.
No, Your Honor, thank you.
Mr. Ross, if you step down, please.
Yes, ma'am.
All right, will there be any other evidence on behalf of the defense?
No, Your Honor, thank you.
Ms. Russ,
Yes.
state in a moment, or do you know when?
I will not present any rebuttal evidence, Your Honor. Thank you.
All right, ladies and gentlemen. All right, all of our members of the jury are outside of the courtroom. Before we get, well, anything we need to address right now?
We do now, Judge. I was tasked with doing something last night in reference to Defense Exhibit 1, and I did not give it to you before we brought the jury in. I do have copies for Madam Clerk. I have a copy for the state and for the court if they like. I felt like I should give it prior to doing my task at the close of state's defense evidence.
I think that's a good idea.
Thank you.
Thank you.
Thank you so much.
Thank you.
And if there are any questions, the original is still in the back room. But yes, Judge, now at the close of all evidence, the defense renews their motion to dismiss. I believe now the burden is shifted. There's evidence that would show that Mr. Ross did not kill Lyric Woods, and there's also information that shows that his actions in reference to Devin Clark were justified. We would at this time ask that charges be dismissed.
Thank you, Mr. Trapp. Unfortunately, at this point, the burden doesn't actually shift. I have to take the evidence in the light most favorable to the non-moving party. It's a totally different issue when we get to self-defense. But at this point with the motions, again, need to view all of the evidence in the light most favorable to the state when making this decision. I will respectfully deny the defense motion. I will find at this point, although certainly have been other issues that have been raised, there's still sufficient issue on or evidence on each and every element. The statement was proved for first-degree murder. To proceed to the jury, I will note the defendant's exception to my ruling. If I didn't note it earlier, I think I did. I will also note your exception to my earlier ruling as well.
Yes, Judge.
All right. First, let me go through the non-substantive instructions. So we're going to hold off on the substantive one. We'll deal with that all together. I've already added one based on the defendant's testimony. So are you all with me so far?
Yes, Your Honor.
All right. We'll be giving 101.05 function of the jury, 101.10 burden of proof and reasonable doubt, 101.15 credibility of witnesses, 101.20 weight of the evidence, 104.05 circumstantial evidence, possibly, I'm not sure, we have to discuss this, 104.50. I don't know that we actually had anything introduced simply as illustrative.
I believe defense 1.
All right. Should we call that a diagram? Would that be fair?
Yes, Your Honor.
Okay.
And I do believe all the photographs were introduced as substantive evidence.
So I'll give 104.50, the diagram that was introduced during the defendant's case. 104.50, photographs and video as substantive evidence, since we had 2 videos, I believe.
Yes, Your Honor. 3.
3 videos. 3 videos and the photographs were all introduced substantively. I don't think there was anything else that the state introduced that would fall into these categories.
I don't believe so, Your Honor.
All right. 104.65, the stipulations between the parties. 104.94, testimony of expert witnesses. I'll be adding 104.60, which is admissions, which would be if you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, then you should consider all of the circumstances under which it was made in determining whether it was a truthful admission and the weight you will give it. I don't know if either party has objection to that. Normally that's given because admissions are made outside the courtroom, but there certainly were admissions made in court. Either party have
I was going to request that instruction, Your Honor.
any objection?
No objection to that, Judge.
All right, so before we get to the substantive offense, let me start with the state. Are you requesting any other non-substantive instructions?
Yes, Your Honor. I'm requesting 104.10 motive I'm requesting 104.20, testimony of interested witness. I'm requesting 104.36, flight in first-degree murder cases. I'm requesting 105.20, impeachment or corroboration by prior statement.
Okay.
I'm requesting, sorry, I skipped one. I'm requesting 104.70, confessions. And 105.21, false, contradictory, or conflicting statements of the defendant.
105.21.
21.
Let me clarify a couple of the ones that you're asking for. Impeachment or corroboration, 105.25. Who does that apply to?
Mr. Sykes, Your Honor.
104.70.
To the defendant, Your Honor.
Hold on just one second. So, confession instruction deals, it looks like, mostly with confessions that occur while somebody's in custody.
It does, Your Honor. I was reviewing the case law and I could not find anything for that one or for 105.21. I could not find a case where it involved a statement made to another party other than a law enforcement officer. And it was not clear to me from the pattern instructions that it having been to a law enforcement officer was required for that instruction, or if that's just the way the case law has generally shaken out on this particular issue. I do have a couple of cases regarding that have interpreted this instruction and where they have found it to be appropriate, that I'm happy to share with the court and with the defense as well. And
Assuming those cases, though, again, are dealing with custodial interrogations versus statements made while testifying.
if I could have just 1 second, Your Honor.
Yeah.
I've got a couple of cases here. Both of the cases that I do have do involve statements to a detective and then an inspector, respectively.
All right, I'll think about it. 105.21, conflicting statements. Who is that applying to?
Yes, Your Honor, it's conflicting statements of the defendant, false, contradictory, or conflicting.
All right, let's talk about that because what are you contending were the false or conflicting statements?
The version of events that he provided to Christian Sykes and the version of events that he told the jury here in court. Again, all the case law on this involves a prior statement made to law enforcement rather than to a non-law enforcement witness.
Okay. All right. Mr. Trapp, let's start with probably the easy ones. Any objection to 104.10, motive?
No objection to that.
And 104.20, testimony of an interested witness?
No, I believe that's appropriate.
All right, let's do the hard ones.
Yes.
104.36, the instruction on flight. Do you object?
I do object, and I'm going to pull it up so I can have the language in front of me. I had 104.70 in front of me at the moment.
There's only one addition to that, just a sentence that says, further, this circumstance has no bearing on the question of whether the defendant acted with premeditation and deliberation. That's the only difference.
Yeah.
Let me just hear from you, Mr. Trapp, as to
Yes.
why you think that the flight instruction is not appropriate in this case.
Well, I just want to make sure I saw the language before I responded. In this instance, the evidence would show that Mr. Ross and these three individuals went to some location that was at the
Flight
direct.
would be after the crime.
Yeah, yeah. And so after these things occurred, Mr. Ross wouldn't have had a reason to remain where he was at this location. And typically when we're talking about flight, they're running away from someone or something. And
I'm
my
going to
hope,
imagine the state's contending his going to Delaware is the flight.
and I think that there's evidence that would contradict that. Mr. Ross was told to leave. He was not allowed to stay at his location. In fact, he was told to go stay with his father in Delaware. And that's why he got this ticket. And that was testimony both from Mr. Ross and from Mr. Bryant. And that could create some kind of confusion with the jury or contradict what is in evidence that his reason for going to Delaware was to get away from this situation versus not being able to stay at his residence.
Yeah, Ms. Orr, it seems like as of right now, the uncontradicted testimony presented by the state as well as the defense is that it's not that he chose to leave, but that his mother told him to leave. And so I think the flight instruction requires that he do something in order to avoid apprehension or detection.
That is true, Your Honor. However, the case law also states that the fact that there may be other reasonable explanations for defendant's conduct does not render the instruction improper. And it's not just the leaving from North Carolina to Delaware that would support this instruction. What the case law requires is that the court may properly instruct on flight whenever there is some evidence in the record reasonably supporting the theory that the defendant fled after the commission of the crime charged. There must also be evidence that the defendant took steps to avoid apprehension. The bar for this is low. And such steps may include an action that was not part of the defendant's normal pattern of behavior. Your Honor, and additionally, for the record, that is State versus Reed, R-E-I-D. And that is 25 NC App Lexus 835. Additionally, Your Honor, in State versus McCormick, M-C-C-O-R-M-I-C-K, 837 SE 2D 383. The court, referencing another case, but also holding in this case, stated that in State versus Anthony, our Supreme Court held an instruction on flight was proper, where after shooting the victim, the defendant immediately entered his car and quickly drove away from the crime scene without rendering any assistance to the victims or seeking to obtain medical aid for them. I think that's completely what the evidence in this case would support. Additionally, Your Honor, in McCormick itself, the evidence showed that the defendant shot the victim multiple times and then fled the scene, but that he also then took other steps to avoid apprehension, including discarding the weapon and running from a traffic stop that was attempted to be conducted on him. The case law also supports the idea that taking steps to avoid apprehension is part of considering the flight instruction. And I would submit that the defendant took those steps. By his admission, he discarded evidence in this matter that he took from the scene. He also then sent a series of messages trying to obfuscate that he was even there at the scene at the time. And so I do believe under all these circumstances, that the flight instruction is appropriate. I also believe that there is an open question of whose suggestion it was that he go to Delaware. I believe Mr. Bryant testified that it was Isaiah's suggestion, not his mother's suggestion. He said his mother, Miss Cordero, never mentioned that to him when he was over there before he picked Isaiah up, if I'm recalling his testimony correctly, Your Honor. And so I would ask for this instruction.
Can I see that second case you mentioned? Yes, ma'am.
Yes, Your Honor. Can I have a copy for the defense as well? May I approach?
Thank you. So I think that your argument's closer than I really thought it was going to be. But I think that the testimony as it came in was the defendant did leave the scene, but he wasn't chased by anybody at that point. There was no police officer surrounding. Nobody knew what had occurred. That he went back to where he lived and stayed there. And although there may be some testimony that sort of calls into question maybe whose idea it was pretty clear that the defendant was told he had to leave. He ended up at somebody else's house. And all that, the motivation behind that was not that his mother thought that he had killed somebody, but that he had damaged her car. I'm not sure what else may have been in that mix, but that was at least the testimony that came in. So I think it's a good request, but I'm going to deny it.
Thank you for your consideration, Your Honor.
Mr. Trapp, 105.25, impeachment or corroboration.
It's 2-0, Your Honor.
Sorry, 2-0. Yes. understand I won't use Mr. Sykes's name in that instruction, yes. All right, 104.70. Mr. Trout? I certainly wouldn't give the second half of that instruction, but do you have an objection to the first paragraph?
I do, and when I was looking at the note for this, this is the one that originally caught my attention. It says that North Carolina General Statute 15A211 requires that a complete electronic recording be made of a custodial interrogation conducted at a police station or other place of detention and criminal investigations in relation to this. And the note just goes on further to say that this has to be some type of interview scenario or some type of statement made outside of court. This, I don't know if our conversation or the statement that Sykes is referring to would fit this category. And I think one of the reasons is because I guess they're looking for the safeguards that confession can be actually recorded and reviewed rather than just recollected.
So it's an interesting thing because the state is, and you're not going to deny that that Mr. Ross, when he got on the stand, admitted at least one of the killings.
Yes.
So, that is a confession, and the state is totally going to argue that, and they totally can.
Yes.
But I do think that the confession instruction was created and designed more for custodial confessions. But by the same token, he did sort of also confess to Mr. Sykes if the jury chose to believe him. So
I would just note that as I'm looking through this rule and what is encompassing, the rule keeps talking about, if this was custodial, then this needs to be recorded and at a place of detention, and it can't just be out in a car or somewhere out in the street. And I think that's where I'm getting at. I don't know if it was designed for this kind of conversation on a video chat that can't be memorialized.
no, I mean, the instruction itself is pretty simple, though. I'm not sure it cuts against you. It says that the defendant, if you find, first they have to find that he did confess, the defendant committed the crime charged in this case, then you should consider all the circumstances under which it was made and determine whether it was truthful confession and the weight you will give it. Let me think on that one just for a minute. All right, and the conflicting statements of the defendant?
I believe that's more an argument that the state would argue at closing rather than it being a jury instruction. And I was going through my notes, I didn't see anything conflicting in his testimony either yesterday or today, and that might be more an opinion or perception that can be argued at closing based on the attorney's interpretation of what was heard and what we know. But
Well, I think the state's contending that Mr. Ross confessed to Mr. Sykes and that his statements to Mr. Sykes were then contradicted by his own testimony here in court.
well, the statements that were made in court verified that Mr. Ross spoke with Mr. Sykes and explained what was actually said. And so we can't
Your
really
own elicited testimony was contradicting Mr. Sykes' testimony about what Mr. Ross said.
I'm trying to make sure I understand your words because I had my words going through my head too. It's my understanding that Mr. Ross would have had to say something in this rule, and then it be contradicted here in court. But what Mr. Ross did is Mr. Ross confirmed what he said and said that wasn't what I told Mr. Sykes. And I think that's a little bit different because there isn't anything here to verify what Mr. Ross actually said then. Unless we're talking about what he actually said on this witness stand, and that's what we're referring to, I think there's a little bit of a difference in how the rule was, I thought, meant to apply.
I don't think it matters, false or contradictory statements. I think they can come outside of court or inside of court. So you have two conflicting statements. one said the defendant said X, one said the defendant said Y, which would be no different if he'd made the same statement to law enforcement and then got on the stand and contradicted that statement. So I'm going to note your objection to that, and an exception to my ruling. I'm going to include that instruction. I'm just in an abundance of caution. I think maybe that first paragraph could apply in this case, but I'm not going to give the instruction on confession. Like I said, I think it probably could apply in this case, both with Sykes and with his testimony, but it's not what that originally was designed for. I know you're probably going to argue pretty strenuously about that in terms of your closing argument, so I'm going to leave you to it.
Your Honor, would you mind if I just put a couple of things on the record about that instruction just to preserve it?
Yes, please do.
Thank you, Your Honor. So I would say that the sort of note with regard to instruction 104.70, the very last sentence does say, if evidence is introduced that the defendant made a custodial statement, that you give the second set of the instruction. So I think that part of the instruction contemplates a custodial statement, which would lead me to believe that the first part of the instruction contemplates something else. And additionally, the case law states that the instruction is appropriate where the record includes evidence tending to show that the defendant confessed to the charged offense. In this case, it was also a first-degree murder. And then the court goes on to say, confession is defined as a voluntary statement made by one who is a defendant in a criminal trial at a time when he is not testifying in trial and by which he acknowledges certain conduct of his own constituting a crime for which he is on trial, a statement which, if true, discloses his guilt of that crime. And I would say that his statement to Mr. Sykes that came into evidence that he shot Lyric because she was a witness to him shooting Devin would be a confession to first-degree murder with regard to her. So that was going to be my argument with regard to confession, but of course it is in your discretion.
It's a good argument. All right. Anything else? Any other requests on behalf of the state?
No, Your Honor. Thank you.
All right. From the defense?
No, Judge. Just once we get to the substantive part, that's when I'll have more conversation.
All right. So you have no other non-substantive requests and no objections to anything else that's being proposed other than the ones you've already put on the record?
That's correct, Judge.
All right. Let's go to the substantive charge then. So I have started and submitted to you 206.10. So let's start. There are two big issues. And I almost think we have to start with the potentially harder of the two. So I am going to instruct on self-defense. And I'm assuming that that is a request from the defense.
Yes, Judge, that's correct.
All right. So, is the state asking or requesting for the aggressor doctrine for instructions? I don't know, given either versions of events, that would qualify.
I'm not sure either. I will not request the aggressor language at this time.
Yeah, I don't think under either factual scenarios that Ross, the defendant, would have been the aggressor, who then Mr. Clark or Miss Woods then reacted, and then I don't think that applies. Then the second sort of choice with that goes with the idea that he, though acting in self-defense, used excessive force. So, are you going to be requesting that part of the instruction?
I am, well, for the record, I'm requesting that self-defense not be given. And I do have an argument as to that, but I understand you've decided based on what you've heard, I am requesting the excessive force portion of the instruction.
All right, talk to me about your objection to self-defense.
Yes, Your Honor. So self-defense requires that the defendant, it appeared to the defendant he believed it to be necessary to kill the deceased in order to save himself from death or great bodily harm. His belief was reasonable under the circumstances, that he was not the aggressor, which we've kind of already just discussed, and that he did not use excessive force. I think the bottom two elements 3 and 4 of self-defense would get us to voluntary manslaughter. However, the courts have held that the defendant is not entitled to a self-defense instruction when he maintains that he did not fire a gun, did not intend to shoot anyone, and did not know anyone had been shot. Now, that's not quite what we have here, but it is with regard to Miss Woods. The defendant either shot her or he didn't. And so he is not entitled to a self-defense instruction with regard to Miss Woods's homicide, because there is no evidence in the record from which the jury could find that she ever posed a threat to him. And so we sort of have to separate out then her from Mr. Clark. And Your Honor, courts have held,
I agree with you as to Ms. Woods.
this is regarding Mr. Clark.
Okay, so let me just stop right there. Are you requesting a self-defense instruction as regards to Ms. Woods?
No, Judge.
Okay, all right, so, all right, now, talk to me about Mr. Clark.
Yes, Your Honor. Your Honor, our courts have held that, excuse me, let me get to the right section. There is a case, it is State versus Revels, that is 195 NC App 546. Revels is Revels. This is a 2009 case. Your Honor, in that case, it does involve a knife rather than a gun, but two women essentially were fighting. Neither one of them had the knife on their person at that time. At some point, a knife was introduced into the argument. The defendant, Revels, disarmed the victim, Strickland, and then proceeded to stab her multiple times, resulting in her death. What the court held was that while there was evidence to permit a reasonable juror to find that Strickland was killed with her own knife, and I would say in this case, there's sufficient evidence that the jury could conclude that Mr. Clark was killed with a gun that he introduced to the scene, that there was no evidence as to where the knife was before it was introduced in the fight, how or by whom it was introduced, how the defendant obtained it, and then most importantly, why she believed it necessary to stab Strickland multiple times after disarming her. I've heard no explanation for why it was necessary to continue firing shots at Mr. Clark as he turned his back and left from the area of the initial confrontation with Mr. Ross. If even assuming in the light most favorable to the defendant, because that's the standard on self-defense, that Mr. Clark did in fact threaten Mr. Ross with the gun. Once he disarms him and Mr. Clark is moving away, there is no further threat to him.
It's an interesting point, Ms. Orr, because in your cross-examination, you, I think, tried very hard to nail the defendant's feet to he was facing Mr. Clark while he was firing the gun. I think during your cross-examination, Mr. Ross never said that he ever fired the gun while Mr. Clark had turned away from him. I'm assuming that's what that line of questioning was there to establish.
He did say it on his direct examination, Your Honor.
He did?
Yesterday, he said, find it, that he got control of the gun, that he started shooting, that he just pointed and squeezed, and then that Devin started moving toward the area where Lyric fell, and then he fell on his face.
Yeah. I don't know if you ever testified that he fired that gun at Mr. Clark while he was facing away from him.
Well, I do have an additional argument in connection with what he did testify to today. which is that excuse me, let me find my notes. That he couldn't see if he was firing at him, and he could not see what he was firing at. That it was dark outside and he did not have the best vision. What the case law has held with regard to the self-defense instruction is that clearly a reasonable person believing that the use of deadly force was necessary to save his life would have pointed the pistol at the perceived threat and fired at the perceived threat. That this sort of vague, I was just shooting and I didn't know what I was shooting at, does not rise to the level of self-defense. And that is supported by the North Carolina case law. Specifically, that quote is from State versus Williams, 342 NC 869, a 1996 case, which I do have a copy of here as well. Courts additionally have found that the self-serving statements of a defendant that do not amount to evidence the defendant formed any subjective belief that it was necessary to kill the deceased in order to save him from death or great bodily harm does not rise to the level of self-defense. Again, once he has the gun in his hand, and I do believe his testimony supports that Devin moved away from him toward where Lyric was lying, whether that's face front or face back. He is moving away, and so he continues firing in some non-specific direction. Additionally, Your Honor, excuse me one second. State versus Rush, 340 NC 174. The court noted, this is a 1995 case, the court stated, we also note that the fact that the victim had been shot in the back of the head and thus could not have been facing the defendant when he was shot strongly negates any theory of self-defense. Mr. Clark only had one front to back shot. The other shots to him were all back to front. He could not have been facing the defendant at the time the defendant was firing.
Mr. Trout?
I just want to make sure we're talking about self-defense for Devin Clark. Okay. There's been testimony and information that Devin Clark, and I got to look back at the medical examiner report, but I thought he was shot twice in the front and 4 entries in the back. But the idea that he was shooting blindly, I have read State v. Williams, and that would be a situation where an individual was not they almost said that they weren't shooting at a particular person, they were just kind of shooting, whereas the threat that was in front of Mr. Ross was directly in front of him. And the idea that just because you take a gun or a knife or a weapon does not neutralize the threat. There's testimony that shows that Mr. Clark was a bigger, stronger individual, and he could have then regained the gun. Mr. Ross just saw Devin kill this other individual. In his mind, he believed that that was an immediate threat for his physical bodily harm. And I think it's a justified question to put in front of a jury for them to decide. And this idea that because Devin was shot in different areas, it goes to his statement. Because I think the question really was more along the lines, did he even know that he had shot Devin? He wouldn't have known. And that's where the whole thing about it being dark came out. Now, when Devin eventually fell down, that's when he realized his injuries. He couldn't say if he shot him 1 time, 2 times, or whatever. I think that's what goes to the dark and not being able to see. But in his mind, at that moment, in that minute or however long it took, he thought his life was in danger, and the only way that he would survive was by shooting the gun. And I think that put in front of the jury could decide one way or the other. I think it's appropriate.
No case law?
I was reviewing case law as we were talking just now. Hold on one.
Mr. Trapp, the state has argued you shoot somebody in the back, you absolutely cannot be acting in self-defense.
I would like to see the case. I don't think that's the rule. I don't think it's a hard and fast rule that just because someone gets shot on the side or the front or the back, it is or isn't self-defense. And I believe that based on, we're talking about, at this point, a child who was put in a extremely high, anxious experience moment. It would be reasonable for this individual to react and respond in that short amount of time. And just because an individual who did get shot in the front, it's at least from the medical examiner's report, as well as in the back, kind of in the same location, it would not negate.
I think that the shots that were in the front, one of them was to his foot, I believe.
And one was in his chest.
That is correct, Your Honor. I misspoke. The one to the foot was slightly front to back. The one to the shoulder was front to back. And the other 4 were back to front.
And so that would show that the threat was in front of him. And so if an individual is pulling the trigger multiple times, if the individual did turn, then this person would, or any individual for that matter, wouldn't then stop because that's still a threat. I think that if this were a difference in time, let's say there was evidence that the individual was shot and then minutes later they continued. But this is all within one succession. Even the witness who testified about the sound of the shots said that they were rapid, boom, 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 boom. And that would show that this span of time was so short that we cannot say, oh, this first one was okay, but the next 3 were not, because they all happened in one consecutive session. And that is the moment where Mr. Ross thought that his life was in danger. The moment didn't change.
So, Mr. Trapp, your client's testimony on stand was the defendant's in front of me. I think he testified yesterday when you were standing next to him. He was maybe a foot or 2 away, and that the testimony from your client today is it was so dark and my eyesight was so bad, I had no idea what I was shooting at or where. And that, based on his testimony today, is not that Mr. Clark got away from him and he was still scared and kept shooting. But in fact, his testimony was that he was shooting at him while he was still right in front of him.
I believe his testimony does justify that he did shoot him when he was close. And I don't think there's any refuting of that. And I think that might have been the initial shot here to the chest. And I believe he kept pulling the trigger to get the aggressor away. And I think what he's talking about is because it's so dark and the person's wearing clothing, you can't actually see that if or where he got shot. I think that's more along what he was talking about, not this idea that A, he didn't shoot the gun, and B, that he was in front of him. But there's a possibility. There are instances where guns are fired and people or individuals go like this because they're looking to see if they've been hit. Because this isn't a well-lit, there are no lights there or anything along those lines, Mr. Ross would not have known if or how many times he had hit Mr. Clark. I think that's what that testimony was all about, even if it's close, even if there's this altercation where he said he headbutt him and took the gun and started firing. This isn't like a trained law enforcement officer who knows the sights and all these other things. This is a kid who was trying to save his life. So I think...
Even though his testimony today totally contradicts the physical evidence then?
I don't know if it contradicts the physical evidence. I think it supports this idea that he was firing until his attacker was no longer a threat. I think
Not his testimony today. testimony today is I faced Mr. Clark, I shot at him, then he went around the car and fell down on the opposite side of the car. That was his testimony today.
And I think that I don't believe we're saying the wrong thing, because once he fell down, he was no longer a threat.
Yes, but the physical evidence would be that he shot him in the back multiple times, which is not what your client testified to today.
I guess I'd have to read the transcript to kind of understand that for sure. But in this instance, because of this small window, this small frame of time, I think that it's all one exchange, it's all one occurrence. And for an individual to defend themselves, to have the opportunity to defend themselves, they need to have that moment to do so. And for us to kind of slice it up into one shot, one shot, one shot, that's not how an individual in that position would be looking at it. And I think that's what the jury would be asked to do, and that's why I think it's an appropriate jury question for them to decide. A, was he defending himself initially? Did that at some point change? And then we'll talk about excessive force. Was his use of self-defense, I think that's why that part of the instruction is important. Did he go beyond what was necessary to defend himself? And that's where the jury can decide, well, he was shot in the back. Maybe it was excessive force. But I think it still is appropriate based on the evidence that we have right now, to at least provide that instruction for the jury to decide it.
So, Ms. Orr, in different from the cases you presented, we know where the gun came from, what we think is the gun. We have conflicting stories as to why it got introduced into the situation. We certainly have testimony in this particular case about why the defendant testified he thought it was necessary. So I can't really check those boxes in not giving the self-defense instruction in this case.
Yes, Your Honor, I just, one additional point is that in State versus Williams, the court held that the evidence showed that the defendant fired 3 shots. After the first shot was fired, the victim turned and began to run away. The victim was struck in the back by the 3rd shot. The fact that the victim was shot in the back while attempting to run from the scene is significant. It is entirely unreasonable to believe that a person of ordinary firmness would have considered the use of deadly force necessary to protect himself or herself from an unarmed person who is running from the scene. I believe that's what we have here.
Ms. Orr, all of your cases are a little older.
They are.
And I think we're all painfully aware, although they were not brought up, that recent Supreme Court law is definitely putting the thumb down on giving a self-defense instruction where it might be appropriate.
Certainly, Your Honor. I would just point out that none of these cases have negative appellate history or have been overruled in any form
No,
or
they have
fashion.
not.
But I do understand the court's point.
Yes. The recent cases that have come down, especially from the Supreme Court that have dealt with self-defense, have overturned a number of cases finding that the self-defense instruction should have been given. And most of those cases have turned, at least in my reading of them, heavily on the issue of whether there was testimony presented where the defendant claimed self-defense and provided testimony that, at a minimum, supported the instruction. I will grant you that the physical evidence and the defendant's version of what he presented do not mesh, and that the physical evidence of shots being fired into the back of individuals goes against the general self-defense instruction. But the testimony that Mr. Ross gave, I think, is sufficient. It's again, in this particular case, I take that evidence against the state to support the instruction as far as for Mr. Clark for self-defense. Now, let's talk about what options the jury is going to have. I'm going to give first-degree murder instruction unless there's some reason you give me, Mr. Trapp, as to both Mr. Clark and Ms. Woods. Trapp, do you have any argument or objection on the first-degree instruction as to Mr. Clark,
No objection to that.
as to Ms. Woods?
No objection, because I believe that there's at least evidence from the state that would support that going to the jury.
At this point, since I've ruled on your motions to dismiss, yes. All right. I am not sure there's evidence of second here, but I will hear from Mr. Trapp. You can go first. Let me ask this first, because it's the defense's choice first. Are you asking for lesser includeds?
Well, I know we had spoken earlier, and we can start our way from the bottom up. We know that involuntary is not appropriate.
Well, I got looking at that instruction.
And I read it too. I really don't think so. There was no accidental discharge of a firearm here. There's no evidence that would support that.
Ms. Orr, is the state requesting that?
I am not requesting in-ball, Your Honor.
All right. Taking voluntary off.
And then looking at voluntary, I believe voluntary will be appropriate in the event that the jury found some means of self-defense, but then felt maybe that it was excessive in some way. That might put them in that realm of voluntary rather than a not guilty. So I think that would be appropriate. But then the next question of second degree, yes, I read that, and I found it hard to fit the pieces in place to have premeditation, deliberation, but no malice. So I would.
The opposite of that.
Yeah, sorry, malice, but no premeditation, deliberation. I'm sorry. So I would suggest no, but typically when I'm dealing with homicide cases, they kind of get the whole smattering of choices, and then they can decide. But especially in this one, I
Are you
don't.
requesting second?
Yes.
Okay. Ms. Orr?
I do not have an objection to that request, Your Honor.
So let me break it down this way. As to Mr. Clark, do you have any objection to the second-degree murder instruction?
Yes, I do.
Let me hear from you.
I don't see from the evidence that we have in front of us how it's either first or it's manslaughter. Either he was acting in self-defense or he murdered him outright. I don't think there's any in between, except the excessive force, which would put us at voluntary. So I don't think there's anything that would support second under anything that we've heard. And I'm going to object with regard to Ms. Woods as well.
We'll get to her in a minute. So, Mr. Trapp, I kind of have this issue as to whether second fits in this particular case. It does seem either the defendant was acting in self-defense or he wasn't. Like, this wasn't a situation where, he was shooting at him and, because he was mad or because he was upset or trying to rob. None of those situations exist. I don't know that this fits.
Well, I think one of the problems we have is that the witness, at least for the state, who gives the confession as we described it earlier, doesn't give any explanation as to what the facts or the details are of this interaction. The only details we have came from Mr. Ross. And so I would agree that that would be something to wrestle with, but for a jury to listen to all these facts and look at the evidence, look at the medical examiner, look at the crime scene, there's a possibility that they could surmise that this was not a situation where Mr. Ross premeditated and planned for this to happen on this timeout to have sex, but that he acted in malice in doing so.
So here's the problem. So in the factual record, either the defendant, for an potentially unknown reason, just shot Mr. Clark and Miss Woods, or he was acting in self-defense when he shot Mr. Clark. I don't know.
Were there in between?
Yeah, I don't know that there's any evidence of anything in between.
Well, because the state's theory doesn't really give an idea of what was surrounding this interaction, that might be why a jury would find that, because they don't have those details, and that's where I'm saying that they could see based on the scene. And keep in mind, we are not asking for a second-degree conviction, but I think that the jury could look at that and say, all right, well, we don't think it's first degree. We don't think it's premeditated and deliberated and with malice altogether. But we do believe that there was malice shown in some way based on the definition that the court provides, if they do, in regards to what malice is. And if they don't, what they believe what it's described as. But if the state does not want it, and if the court is not inclined, the defense sees that understanding.
All right. As to Miss Woods, Mr. Trapp, are you requesting any other instructions other than first?
No.
Ms. Orr?
No, Your Honor.
All right, that seems to fit. All right, we're going to take a recess for 15 minutes. When we come back, I will get you my final ruling and the jury instructions. We're running up against lunch, though, so let me ask each of the attorneys, again, I'm not going to let you go for 3 hours, but give me some idea of generally, I'm not going to time you, but how long you think your closings will take.
I anticipate less than an hour,
Are you going to give both opening and closing?
just closing.
Just closing, all right.
And Your Honor, I believe mine will be less. I think we might be closer to 45 minutes, but I know for sure it'll be less than an hour.
All right. I'm inclined to probably break around noon and have everybody come back at 1:30. That way, we won't break up the closing arguments between the two and the instructions. Is that acceptable to both sides?
Yes, Your Honor.
Yes, Judge, that's perfect.
Okay. Let's give our court reporter a break. So we will be in recess for 15 minutes. Paige, when I get these done, I'm gonna need them printed off so they can look at them. Yes. What? I give them Also, please remember, do not go to the local library to find out if they still retain all of the encyclopedias that they used to have. Don't conduct any other type of investigation or inquiry in any way. You guys have heard the evidence that you need to have in order to reach a decision. So that also means, remember, there's probably going to be a little bit of media coverage on this, so don't read anything or listen to anything. Don't allow anybody else to talk to you about this case. Don't let them talk around you about this case, all right? Lastly, you still need to keep your minds open. You have not heard the arguments of counsel, and you have not heard the law that I'm going to get you that you need to apply to the facts that you have heard, all right? You all have done fantastic. So just remember, you're still under that bubble. When you get back from lunch, you'll come back. You'll hear the final closing arguments of counsel, and I will instruct you on the law. And at that time, you'll be able to go back and begin your deliberations where you can talk to each other about this case. All right? All right. So I'm going to let you go. If you would please be back by 1:30. As soon as we got everybody back and we're ready to go, I'll have you come in here and finish out the last part of the trial. All right? All right. Everybody else, please remain seated. Ladies and gentlemen, you're excused until 1:30. All right, all of our jurors are outside of the courtroom. This is a tough one when it comes to instructions as to where to come down with this. The evidence is definitely contradictory in this particular case presented by both sides, and that creates a sort of unevenness in trying to decide what instructions should go to the jury. What I have decided on the record with the agreement of counsel as to Ms. Woods, there'll be only one instruction. That will be first-degree murder. There will be no instruction on self-defense for Ms. Woods. As for Mr. Clark, I will give first, second, and voluntary with the instruction on self-defense, with the instruction on excessive force. I still need to clean up the instructions a little bit, so what I would ask is if the parties could remain here so I can get you a copy of that, so you can look that over lunch. When we get back, I think I'm going to ask, if you don't mind, if the parties will be here about 1:15. That will give us a chance to talk about if there's anything I missed, and just confirm that the instructions have everything that we need. I do, before we go, have a couple things I want to go over in terms of what to include in the instructions. There are a number of different choices. So, if we can go to the substantive instruction of 206.10. So as to Mr. Clark, it will be under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder, guilty of second-degree murder, guilty of voluntary manslaughter, or not guilty. Summary instructions on those. All right, so first-degree murder, the elements. Second element, in determining the reasonableness of the defendant's belief. I'm sorry, I apologize. We're doing, the defendant would be excused of first-degree murder and second-degree murder on the ground of self-defense if. So we're on the second element of that self-defense instruction. In determining the reasonableness of the defendant's belief, you should consider the circumstances as you find them to have existed from the evidence, including, what are you requesting, Mr. Trapp?
I didn't have the paper copy in front of me. I was trying to load it on my computer. It's still stinking.
if you want to make sure your mic's on.
Sorry, Judge, I was trying to load it on my computer so I could see it, and it just opened up a second ago. So we're at first-degree murder. In particular, we're looking at self-defense. Does not right. All right, so first, the defendant, I saw the first part. So we at second?
Yep.
All right, and second, the circumstances appeared. Need to include size, age, and strength the defendant as compared with the victim.
All right, any objection from the state?
No, Your Honor.
All right,
I think that the fierceness of the assault, if any, is important.
I don't know, the assault you're contending is
From Devin towards Mr. Ross.
pointing of the gun, is that
Yeah.
your,
Yes, ma'am.
all right, anything from the state?
No, Your Honor.
I think the next parenthesis, whether the victim had a weapon in the victim's possession, that would go along with the prior point.
Anything from the state?
No, Your Honor.
All right,
I don't believe reputation is appropriate in this case. There wasn't any evidence that would go either way in reference to that. And then,
and anything else you're asking for?
no, ma'am.
All right. All right, are you contending or asking for, Mr. Trapp, the no duty to retreat instruction?
No, Judge, I'm not.
Okay, so I will remove, beginning with further. All right, then we're on to the elements of first-degree murder. All right, so I think this is correct. Under the definition of malice, if the state proves beyond a reasonable doubt, or it is admitted that the defendant intentionally killed the victim. I think in this case, I'm going to add, or it was admitted, because I think we all agree that the defendant's testimony was he did kill Mr. Clark.
Yes, ma'am.
I'm going to go in the second element. I'm going to go with injury instead of damage. Any objection?
No objection.
All right. I was not going to give the information about proximate cause in the parentheses because it's kind of redundant. Clearly was killed by the gunshot wounds. Is that good with you, Mr. Trapp?
Yes, ma'am, that's direct and concise.
All right, so the fifth element, second paragraph, begins with neither premeditation nor deliberation. They may be proved by circumstances from which they may be inferred, such as, I guess this would go to the state.
Yes, Your Honor. I would ask for lack of provocation, conduct of the defendant before, during, and after. I had crossed out threats and declarations, but of the defendant, so I would ask that that one be left out. Use of grossly excessive force, I would ask to include infliction of lethal wounds after the victim is felled. I would ask to include brutal or vicious circumstances. I would ask to include manner in which or means by which the killing was done. I would ask to include, and I would ask to exclude ill will between the parties.
Mr. Trapp, objection to any of those?
Well, I'll let the court know I agree with the two that she excluded. I think the one parenthetical about affliction of lethal wounds after the victim is felled, I don't know if there is any evidence to show that they were shot after they had fallen.
I don't know that I have any good evidence on either side telling me when the wounds were inflicted and where
Right.
the victim was.
But that, I don't know if that, I feel like we need evidence or information to support some of these instructions. And that one
I'm gonna
almost infer.
deny your objection. I'm gonna note your exception to that. I'm gonna find that evidence that since the victim was shot in the back, and the defense is contending that some of those shots were made while Mr. Clark was apparently running away, or the concession, he was moving around the car, would support that instruction.
Okay.
Next one. You objecting to the brutal or vicious circumstances of the killing?
I know this is obviously a sensitive subject, but based on the evidence, we know that this was, at least for Mr. Clark, shots that weren't at close range. I don't know if, no objection. I believe that there's enough evidence from the state to argue one way or another.
And the final one, manner in which or means by which the killing was done.
No objection.
Okay. All right. All right, so under the voluntary manslaughter instruction, there's that whole paragraph on the heat of passion. Are you requesting, Mr. Trapp, that instruction with voluntary manslaughter?
No, Your Honor, I believe that implies a different kind of fact pattern.
All right. State have any comment on that?
No, Your Honor.
I think I'm inclined to take all of that, since the heat of passion is not something that I don't think would apply
That's correct.
under the evidence that's been presented. I'd be inclined to take that whole sentence out and just begin to find the defendant guilty of voluntary manslaughter. Would that be acceptable?
Yes, Your Honor.
Does that make sense? So we would go right from, if the state must prove that the defendant, oh, that comes out, sorry. The state must also prove that the defendant did not act in self-defense, eliminate the rest of that sentence,
Okay, I see it now. Yes, Your Honor.
and then go right to, for you to find the defendant guilty of voluntary manslaughter, the state must prove three things.
Yes.
All right. Does that sound good to both parties?
Yes,
And
Your
then
Honor.
Your Honor would take out the sentence, a killing is not committed with malice if the defendant acts in the heat of passion, and then
Yep.
straight to the elements.
Yep, go right to the
Perfect.
elements. Let's go to the third element of voluntary manslaughter. I would have that third element read that the defendant did not act in self-defense, or, though acting in self-defense, used excessive force. Everybody agree?
Yes, Your Honor.
All right. Taking out of the next paragraph anything about the aggressor. State proves beyond a reasonable doubt the defendant, though otherwise acting in self-defense, used excessive force. Defendant would be guilty of voluntary manslaughter. Yes?
Yes.
Yes, Judge.
Take out all of the language on involuntary. All right.
Did you say on involuntary?
Involuntary, yeah. Sorry. Final mandate. Take out all of any of the aggressor language. All right. That should do it. I'll get, if you all stay, I'll ask our wonderful clerk if she'll print off a quick copy of this so you can take it with you. Is there anything else that you wish to address before we take the lunch recess?
Your Honor, the fourth paragraph under the final mandate in the draft discusses the heat of passion. I just wanted to,
I'll make sure that gets eliminated.
thank you.
All right. Anything else, Mr. Trapp?
Nothing for the defense. Thank you, Judge.
That's what I see right now, Your Honor.
All right, we'll be in recess until, let's just come back at 1:30. That way everybody has a chance to get lunch and review everything. And then we'll address any changes or adjustments we need to make to the jury instructions. Everybody ready to go on closings?
Yes, Your Honor.
Yes, Judge.
Okay, so Mr. Trapp, you're going to start.
That's correct.
All right.
I do have one screenshot from the Petro video that I intend to use during my closing. I will mark it and put it in evidence after I use it, if that's acceptable.
Yeah, I don't think you have to, but
Okay.
if you want to, you can.
Sure.
I mean, the whole video is
Is
in
in.
evidence, so
Correct.
as long as you're not using something that wasn't introduced into evidence, I think you can use anything you want.
Thank you, Your Honor.
All right. All right, we'll be in recess till 1:30. I gotta get it to you.